Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a recent federal court decision declaring Canada's ban on single use plastics unreasonable and unconstitutional. This decision overturns the cabinet order that listed plastic manufactured items like plastic bags, straws, and takeout containers as toxic under the Environmental Protection Act. The decision found that the cabinet order listing these substances as toxic was too broad and that the government acted outside its authority. The case was brought by a group of petrochemical companies, and the provinces of Alberta and Saskatchewan intervened to support the argument that the cabinet order was the latest example of federal overreach into provincial jurisdiction. Here today to unpack the decision are two experts. Brett Carlson is a lawyer with BLG, and Caitlin Mitchell is a lawyer with Animal Justice who intervened in this case. Thank you both so much for joining me today. Caitlin, let's start with how the plastic ban worked. What exactly did it ban? I listed a few items. Maybe you could just expand on that.
Absolutely. So this is an order that was made under CEPA, or the Canadian Environmental Protection Act, which is Canada's toxics law, and really probably our most important environmental law. So it's a huge statute, but the part here that we're dealing with is Part 5, which focuses on toxic substances. And so under Part 5 of the Act, there are a bunch of really important regulatory tools that the government can use to restrict and control toxic substances. So what happened here is the government decided to list plastic manufactured items as toxic under Schedule 1. And once that happens, that basically opens up the toolbox. The government can then use these additional tools like passing regulations or risk management measures to control toxics. And they've done that. They've passed a regulation subsequently restricting certain single-use plastics.
Now, Brett, I think that the issue here and what the federal court found the issue was is that, even if the government has concerns about single use plastics, and we'll talk later about what those concerns are, that if they want to get involved in regulating single use plastics, they still have to act within the boundaries of our Constitution when creating laws and policies that address environmental issues. So, where do you think they went too far in this case in putting single use plastics in that cabinet order as a toxic substance?
Yeah, thanks, Christine. I think that the main issue here was that the order was simply too broad, and this takes us back to really what the scope of the criminal law power actually is. And there's been some back and forth over the past 20, 25 years on the scope of this power. It can be used for valid environmental purposes, but it has to be carefully calibrated. And the fear really is that if it doesn't have a true criminal nature, it starts to look like economic regulation or the regulation of a provincial industry. And it sounds from the court here that that's really what happened. The order was simply too broad.
Now, I want to get into that criminal law power, but first, Caitlin, you work with Animal Justice, so I think people intuitively know about some of the problems that single-use plastics can do for animals and the environment. I think we can all conjure to mind that this awful image of the plastic straw in the sea turtle's nose when we think of the harm that some certain plastics can cause for animals. But why don't you tell me about some additional broader impacts that you're concerned with? We've got about a minute.
Okay. Well, we've all seen the images, whether it's otters with plastic six-pack rings around their neck, emaciated sea turtles, or dead sea birds, pardon me, with stomachs full of plastics. We know that these are substances that are having a devastating global impact. They're causing horrific harm and suffering to individual animals, and they can also have harm at the population level. So, I think what our position was is that it's important to consider these impacts, not only, when you consider endangered species or population impacts, but really to think about the individual animals and the suffering and prolonged deaths that this can cause, whether it's, lacerating internal organs, asphyxiation, just some really genuinely terrible stuff. And to be clear, it's not just single-use plastics that can cause this harm. It's all plastics. They all have the potential to enter the environment and break down into smaller pieces and have devastating consequences for animals.
Now, we've got to go to a commercial break, but when we come back, I want to talk about this was a federal ban. But part of the issue here is jurisdiction. And we know if the government may have a legitimate concern, but they still are confined to the Constitution. So I want to talk about what provinces might be doing about this issue when we come back. Welcome back to Canadian Justice, where we're discussing a recent federal court decision that found that a federal plastics ban is unconstitutional. Now, Brett, in the last segment, we talked about some of the concerns that organizations like Caitlin have about single use plastics. We know that the federal government has their concerns, but anything they do to address those concerns, must be within the division of powers architecture of our Constitution. And we know that there are provincial and even municipal restrictions on the use of single use plastics. Now, this varies across the country, but we know that some levels of government are already regulating in this area. So, why would the federal government be stepping in here, especially if there's a question about if they have the authority to do that, even?
Yeah, so it's a good question. And to some extent, we're seeing the same dynamic play out on many different environmental issues across the country. As we can appreciate, the framers of the Constitution didn't exactly envision environmental regulation when they drafted it. And so every few years now, we're seeing a new issue come up where both the provinces and the feds want to regulate. And in this case, it's not about um, plastics per se. I think everyone has an interest in regulating those. It's about who can do what. And the court really picked up on it in this case. And I just want to read a quick quote where they say the ubiquity of plastic in society means that most businesses and organizations will use PMIs and will be under provincial jurisdiction. So that very much reflects the fact that provinces do have a role in this and are playing a big role. And the court has to be extra careful with what they're going to allow Parliament to do under the criminal law power.
Yeah, so I want to talk about that criminal law power. Caitlin, the consortium of plastic companies that argued that this ban was unconstitutional, they said that the cabinet order was being made under the argument that it was a criminal law regulation. And they said that a plastic ban doesn't fall under criminal law. Now, certainly the federal government can use criminal law powers to enact environmental protection legislation. And we might think of other cases that involve toxic chemicals like mercury and lead and asbestos. And this was all considered by the federal court. But how dangerous or how toxic does a chemical need to be to meet the test to bring it in with the scope of the criminal law? I think a lot of us might automatically see mercury as quite a different type of product than, or asbestos is a very different product from, a plastic shopping bag. How does plastic, in your view, meet that test?
Well, it's an interesting question. And certainly in the Hydro-Quebec decision, the Supreme Court did give us some useful guidance. So there they found that CEPA, the Canadian Environmental Protection Act, protects not only against substances that are toxic per se, so things like asbestos that you mentioned, but that it's also intended to protect against harms caused by substances that may, when released into the environment in a certain quantity, concentration, or condition, become toxic. And when it comes to plastics, we absolutely know that that is happening. They are being released in quantities that are causing devastating impacts right now.
Brett, what's your take on the criminal law power and how plastics do or don't fall within the scope of criminal law power?
Well, I think Caitlin summarized it perfectly there. In the criminal law jurisprudence, there is really this effort by the court to only use that power when the prohibition in question has a criminal character, right? And so you see the courts in the environmental context. That's why they're fixating on the toxicity and the significant harm aspect of it. They're trying to find something or constrain Parliament to something that truly is severe and truly has potential to have significant consequences. It is definitely an unsettled area right now, and we see that back and forth in a few cases. Um, but certainly when it comes to SEPA, we're seeing that sort of toxicity threshold. In this case, the problem was just that the order itself included substances that did not have the scientific justification in the RIAS and the scientific assessments, and it appeared to be a bit too broad for the court's liking.
Now, is part of the issue, Brett, just about 30 seconds, that the term plastics is just, it includes so many different things, includes like hundreds or thousands of different items.
Yeah, it's arguably not a single substance or a class of substances, which is part of the machinery of SEPA.
Right.
That's the language it uses in the
Right. The
statute.
way
And
mercury or asbestos would be a single substance. I mean, these different plastic
that's
items
correct.
are really across a huge spectrum. We've got to go to commercial break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the federal plastic ban, the ban on single use plastics, how it has been overturned by a federal court. Now, Brett, I think environmental protection, most people know that this is a shared federal provincial responsibility. But I think a lot of people can get confused when an issue falls within federal or provincial jurisdiction, especially because all kinds of environmental issues, even if they start in one province, can cross borders into another province. What did the court say about these jurisdictional questions in this plastics case?
It was mostly confined again to the criminal law power, and again, the the underlying concern from the court is it doesn't want the criminal law power to inadvertently, quote, eviscerate a provincial head of competence or head of power. And so, similar to POG, which was an issue in the Impact Assessment Act
That's
reference, and
peace, order, and good government, a part of our
that's right.
constitution.
And so it's going to allow some intrusions, incidental effects, they call them, but it's really when it starts to cross that line and in pith and substance to appear to be regulating a matter under the other head of government that we run into problems.
Caitlin, anything that you want to add there?
Yeah, I mean, I think the challenge with plastic pollution is that, not only once it's released into the environment does it flow across boundaries, into different rivers and streams and through the air, it also enters the bodies of animals who themselves don't reflect boundaries. And so, it can really cause great distance. And that's why it is a national and a global crisis.
Now, Brett, I think there's adding to some of the confusion that people have about when an issue about the environment falls within federal or provincial jurisdiction are some recent cases like the Impact Assessment Act, the greenhouse gas emissions case. Um, and I'm wondering, where does this case about plastics fit into that debate? Does this add any clarity about when an environmental issue falls within federal or provincial jurisdiction?
So, because the case was dealing mostly with the criminal law power, it has some utility going forward, I think, for cases like the clean electricity regulations, oil and
Exactly.
gas emissions cap.
Because I think that the
Um,
clean electricity regulations that are being proposed, that is being proposed partly on the basis of criminal law power. Is that right?
Ultimately, we'll have to wait to see, how Canada would argue that. But I think most commentators and academics are speculating that it likely will be a criminal law issue, as most SEPA issues tend to be under the criminal law. That was, all the way back from Hydro Quebec, more recent cases like Syncrude. So I think we're all sort of waiting eagerly to see how this is going to have a ripple effect through future challenges dealing with SEPA.
Caitlin, is there anything you want to add to this about where the criminal law power in future cases, how this decision on criminal law power might apply in future cases, whether it's related to the clean energy regulations or the proposed emissions cap, or maybe in other areas of law?
Yeah, absolutely. It'll be interesting to see, and it will be interesting to see what happens, of course, on appeal. So, I think the story is not over yet. But I do think the door is still certainly open to using criminal law power. Of course, we know that the criminal law can be used for matters of environmental protection and for matters of animal protection, which is one of the arguments we made here. But I think the court here was signaling that they will take a hard look at the reasoned apprehension of harm to ensure that there is a proper use of the criminal law power now and in the future.
Now, Brett, another issue in this case was whether it was that the Minister of the Environment refused to allow a board of review to assess the alleged risks associated with plastics, even after the plastics industry objected to the ban. What is the purpose of that review, and what did the court say about the minister's refusal to allow one in this case? We've got about a minute.
Yeah, I think that there was some significant opposition to the order, and there is a rather discretionary mechanism in the act allowing for the minister to call this board of review, and the minister ultimately didn't, and the court simply held that this lacked transparency, and the quote is completely renders the BOR decision unreasonable, right? So it was really a transparency thing that trickles from the old Vavilov case or the new Vavilov case on administrative law grounds.
Now, we've got to go to commercial break now, but I want to discuss when we come back what this decision means for the future. I mean, am I going to get plastic straws back? Am I going to get shopping bags back? Or is it going to depend on where I live? Or is it going to have no impact at all? We will be right back. Welcome back to Canadian Justice, where we're discussing how a federal court overturned Canada's ban on single-use plastics. Now, Caitlin, what is this decision going to mean in practical purposes? I mean, I do love sea turtles, but I really hate plastics. I really hate these paper straws that dissolve in my iced coffee. I know that sound is going to drive you crazy as a animal rights activist, but what is it going to mean for people, for consumers? Are they going to return, or is it going to really have no effect, and or does it depend on where you live?
There's not going to be an immediate effect from this decision, and that's for a few reasons. The first is that the listing decision itself doesn't actually change anything. Adding plastic manufactured items to the list of toxic substances just opens the door for future regulation. So that's the first point. But the second point is, of course, since this case was brought, SEPA has been completely overhauled through Bill S5, which passed this past June. And so the court's decision here certainly could be relevant to a future challenge to the new act, which also, brings over plastic manufactured items on the list of toxic substances. But it does not immediately, strike it from the list or anything like that. And so I think I'd be surprised to see the feds getting out of the business of regulating plastics, since we know this is a serious crisis. And in fact, I hope that going forward, we start to see stronger restrictions on things like ghost fishing gear, for instance, because there are so many different items that are causing harm to environment and to animals. And for the straws, I don't like the paper ones either, but just use
I
no
do have
straw.
metal ones at home, but
Yeah.
if I'm out, then I'm out of luck, and I have to taste some paper in my coffee. Um,
Yeah.
Brett, one of the issues that we were talking about was that the ban on plastics included. It just said, these plastics. It's terms. It wasn't called single-use plastics. It had another term for it, but it's a really broad category that included potentially hundreds or thousands of different items. Do you think if the list was more carefully tailored, if it said more specific items, um, do you think that could have led to a different result? And what types of items do you think could have satisfied that criminal law threshold?
Yeah, I mean, I can't speculate on exactly what list or combination of substances would have done the trick here, but the court certainly seems to have focused its concerns on the breadth of the order, and um, conceivably there's a scenario where it was a smaller list, and that list was supported by some sort of substantive scientific evidence in the earlier phases of this order, and we certainly could have seen a different result in that case.
Caitlin, what do you think? Do you think that there are changes the government could have made to make this more tailored, or do you think there are things that they could do now to address single-use plastics that are within the bounds of their powers, and what might those changes look like?
Absolutely. I think there are lots of approaches that the federal government can and should still take. So, for instance, we've been talking a lot about single use plastics, and right now they've regulated 6 specific items. they could take those 6 specific items, for instance, and put them on the list of toxic substances if they decided to move forward right now before the appeal, of course, takes place. The challenge is all plastic items can enter the environment, and all of them can then break down and be harmful. So it's a real challenge, I think, to go about it any way than the current way, which is just to recognize that inherent risk and to leave it to subsequent regulations to decide, which items to focus on. But unfortunately, the risk is across the board for all plastic manufactured items.
Brett, the government has said that they are planning to appeal. We've got about 30 seconds. How long does that take? And does that preclude them from making any changes to the orders or laws as they stand now?
Yeah, we'll have to wait and see what the next steps will be. I know there's another case dealing with the single-use plastics regulation, which is really the operative part of the ban here, as I understand it. And so, how those two are going to interact, I think, is an open question at this point. But we've got
Right,
another constitutional battle in the
right.
works.
Well, thank you both so much for coming on today. We've heard today about a federal court decision that struck down the Trudeau government's ban on single use plastics. What do you think the right approach is to single use plastics? Do you support a ban or do you see an alternative? And if you do want a ban, how would you achieve it given Canada's constitutional architecture? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.